So welcome everybody to our presentation on the first, what we expect will be a number of tranches of changes to the workplace legislation coming out of the Albanese government's reforms. A couple of quick housekeeping matters before we move forward onto the presentation. Firstly, Ashley Lynch, who was to present today, is unwell. So Alex Ashburn-August has joined us and he will be able to speak on the NES and related provisions. I know that a number of people will have questions as we go through the presentation. So I would ask that if you do want to put forward a question, there is a Q&A tab at the bottom of the Zoom link. If you can submit your questions in there, then we will be able to collate those and attempt to address some of those at the end. By putting the questions there, we will be able to also capture those, and it's our intention to provide a summary of questions and answers to participants of the webinar shortly after we complete today's process. Also, we will be holding further seminars on particular topics. So we will have a short survey at the end of the presentation, and I would invite you to nominate which of the topics that we discuss is of most interest to you. So I'll start the presentation then. Okay. So really what we're dealing with here today are changes that are arising out of three principal pieces of legislation. They are the Secure Jobs Better Pay Act, the Family and Domestic Violence Leave Act, and the changes arising out of the Respect at Work Act. Because of the time limitations, we're really only going to be able to deal with these at a very high level. But as I said, we will come back in future seminars and delve into some of these topic areas on a more specific basis. So I'll hand over to Alex, who can take us through the first part of the presentation.
Thanks, Ben. Yes, as Ben indicated, we're going to give a bit of a broad overview, a number of key issues that are going to be impacting upon employers and workplaces. So I'm going to touch on some key changes to the National Employment Standards and general terms and conditions reflected in contracts of employment. Industrial relations is never easy, it's always complex, and just determining what starts when is part of the complexity that employers are facing at the moment. So what we've tried to do these next couple of slides is just clearly articulate the dates that certain changes are commencing. So paid family and domestic violence leave entitlements commence for most employers on the 1st of February of this year. However, for small business employers, they have a 6-month period to come to grips with the changes, and that will be operative from 1 August of 2023 for those employers. The ability for the Fair Work Commission to conciliate and arbitrate flexible working arrangements, requests and extensions for parental leave both commence on the 6th of June. So there's a little bit of time lag yet on that. Then in relation to some of the employment contracts ones, some of these are a bit more kind of controversial and unusual. Pay secrecy clauses are unenforceable in any contract entered into from 7 December of last year, and we'll talk about past contracts shortly. Prohibition on job advertisements indicating rates of pay less than federal minimum wage or relevant industrial instruments starts 7 January of this year, and then the fixed term contract limits commence later this year, so essentially 12 months after the commencement of the legislation. So looking first at some of the changes around paid family and domestic violence leave, most significant, most important, most obvious is that the NES entitlement of 5 days unpaid leave has now changed to 10 days of paid leave per annum non-cumulative. So it is a use it or lose it entitlement, and that if you don't use it for 3 years and you can't access 30 days, it's still only 10 days. Important to note that it applies equally to all categories of employees. So full-time, part-time, casual, all entitled to 10 days, but a day may be different for a full-time or casual employee, depending upon what their normal hours of work are. The other key item and issue of risk for employers is around confidentiality. So it is important that steps and measures are put in place to ensure that any information or records that you obtain in relating to an employee's situation around family domestic violence is maintained in the strictest confidentiality. An area in the past that we have seen employers kind of, administratively break down is where their payroll system identifies it as paid domestic violence leave. So it's important that there not be a specific pay code for that type of leave and that it's categorised, we would generally say as a special leave or the like. So that's a very important aspect, because breach of that does expose employers to sanctions and fines and penalties. So some of the kind of key operational takeaways that you need to consider is obviously changes to policies, procedures, employment contracts, forms. So all of the kind of framework around all of your various entitlements need to be reviewed to ensure that it's current and up to date. The confidentiality aspect, you need to put in place, processes around that to make sure that documentation that may be provided as part of the evidentiary onus that employees have to prove that they are accessing this leave for a legitimate purpose needs to be maintained. And you would ordinarily say that you should consider similar sort of arrangements that you have for employees' personal medical information. And then the final aspect is really around communication broadly with employees and using this as part of an engagement process and ensuring that you're explaining to employees the support that is available to those that are faced with these sorts of traumatic incidents. And while it's important that you're relaying that directly to those employees who may be impacted and may be scared because of the stigma and embarrassment to self-identify and disclose, but it also has a broader ramification for the organisation because it identifies that you're looking out for those that are part of your workforce and part of your community that may be facing these challenges, and as part of a broader cultural messaging, it is an important aspect. Can you just move that on? I just can't seem to move it. Technology beats me every time. The next aspect is in relation to requests for flexible working arrangements and extensions to unpaid leave. So there's some specific changes to the legislative arrangements around where flexible working arrangements can be requested and therefore considered. And there's a specific process in place that is largely unaltered, that if you get a request, you have to respond within 21 days, you have to give it genuine consideration, you have to meet and discuss with the employee the nature of the changes. If it's agreed, it has to be documented. If it's not agreed, it can only be refused on reasonable business grounds, and there's a requirement to spell out those reasonable business grounds. All of that is largely unaltered from the previous legislation, but where the change becomes, and therefore quite a change of focus, is that previously these sorts of requests were largely in the discretion of the employer. So we would go through that process, we would say, sorry, it's not operationally feasible, and that would be the end of the matter. Ordinarily, there would be no mechanism for review or any further dispute process which was available under the Fair Work Act. Now there is, and that will change the whole way that these issues in particular are addressed. And we've seen through COVID, people have enjoyed the flexible nature of working from home or working at remote locations or changing their hours, and they want to retain those sorts of things. So we are expecting to see a lot more of these flexible working arrangements requests to start coming through the system. And now that there is an avenue for them to be conciliated or arbitrated by the Fair Work Commission, we are expecting that we will see some decisions coming out in the not too distant future, which will provide some kind of framework around what reasonable business grounds are. And there was a recent decision of the Fair Work Commission involving Ambulance Victoria, which is I'd say a concern for employers, because essentially what that decision involved was an AMBO who wanted a particular roster arrangement to deal with family responsibilities around caring for children, which was all very, very legitimate, but she wanted a bespoke and specific roster unique to her, which was out of kilter with all of the other rosters within the area. And essentially the Commissioner, based on the evidence that was presented, formed the view that that was not an unreasonable request, and that because of the nature of the employer's enterprise, that they were compelled to comply with the request. And one of the things they put forward was, well, if we do it for this one, we have to do it for everyone. So it's going to create an unacceptable precedent. And the Commission specifically said on that submission that that was not a reasonable business ground for refusal. And by implication, because we can't make a determination here based on what might happen to other employees at some future time. So ordinarily, you would have expected that sort of decision to fall within the reasonable business grounds exemption, but on that case and the way it was run by the ambulance service, they were unable to establish that to the appropriate evidentiary standard. So that's a real risk for employers in understanding what are the limitations, and this may act as an inducement or encouragement to sit down with your particular employee who's requesting an arrangement to try and get a meeting of the minds and to find some sort of compromise. So key takeaway around this issue is that this is a small wave that's likely to become a tsunami of claims over the next 2 to 3 years, that it'll probably be 18 months before we have some real clarity around what the Fair Work Commission kind of scope around reasonable business grounds is. In the meantime, you'll need to try and address these requests in an open, transparent, but operationally responsible way. So we clearly can't agree to terms that are going to place undue pressure on the business or work colleagues, but we need to try and engage with employees to see if we can come to some sort of mutually acceptable outcome. Next slide, please. So pay secrecy, the sleeping giant. So lots of employment contracts have pay secrecy provisions in them. So essentially, it'll say that the terms of your remuneration and salary is strictly confidential, and any breaches may result in termination of your employment. That's a kind of extreme kind of wording that you would sometimes see. Essentially, from the 7th of December last year, any new contract that had that clause in is of no effect. And basically, employees now have a workplace right to disclose information about their remuneration or the terms and conditions which impact upon their remuneration, or to ask other employees about their remuneration. Now, that doesn't necessarily mean that another employee has to disclose, or that all employees are going to be out there saying, oh, look, this is what I've got. But if someone does that, then there is no ability to negatively impact their employment. So they can't be disciplined, they can't be terminated, because that would be a breach of a workplace right and a general protection, and that would expose an employer to potentially uncapped compensation. One of the queries about this, and one of the unknowns currently, is that salary is pretty straightforward. We know salary is remuneration. We know superannuation is remuneration. We know other financial benefits fall within remuneration, but it's not clear about what are the additional terms and conditions that relate to remuneration. So for example, I have a bonus scheme, I'm a senior executive, and it's linked to corporate KPIs. Can I identify those corporate KPIs to another employee? They are highly sensitive, they're commercial in confidence. In an ordinary sense, for me to disclose would be to breach my confidential information obligations to my employer, but it's directly related to my remuneration, because if I achieve those key KPIs, then I get a bonus, then I get additional payments. So the scope of that is currently unknown. The examples given in legislation and other kind of areas are all very much around hours of duty and earning penalties and weekends, payments, etc. So the scope of that is yet to be determined. So employment contracts from the 7th of December with such a clause in are of no effect. From 7th of June of 2023, it will be illegal to have that clause in a contract. So if that clause is in a contract executed after the 7th of June of 2023, it is a breach of the Fair Work Act, and that will trigger potential penalty payments for breach. For contracts entered prior to 7 December of 2022 with a pay secrecy clause, those clauses continue to be legally enforceable and binding until the contract is varied or a new contract is entered into. So if pay secrecy for a particular contract is of significant importance to a company, it's important that you ensure that the contract is not varied, the contract isn't altered in any to any extent, or that a new contract is not entered. So one of the issues as this comes up, and there's still some grey around it, is, well, you know, every year we get a salary review and we advise every employee that their new salary is X, and we say, and this is a variation to your contract of employment. It would appear that if that is done in the future, then that will trigger this provision, and that the pay secrecy provisions in the existing contract will no longer be enforceable. So we need to be careful about how those sorts of changes are communicated. So they're communicated in a way that does not trigger a variation of the contract, but it is merely reflecting an entitlement under the existing contract of employment. Next slide, please, Ben. Another significant area is in relation to limitation of fixed term contracts. So these limitations will commence from 6 December of this year. So essentially employers are given a 12-month period to make whatever necessary adjustments. So essentially fixed term contracts, unless one of the exceptions apply, are limited to the shorter of a total period of 2 years or 2 consecutive contracts. Now, they have to relate to the same or substantially the same work. So if there are 2 contracts for very different roles, then that will be okay if they extend beyond 2 years. So often you'll get a temp in, they'll do a particular role, someone else will go on maternity leave or whatever, and they will kind of go to that role, and then another will occur and another and another. Those sorts of arrangements on its face appear to be legitimate, but you would need to make sure that they are clearly identifiable separate roles with separate responsibilities. The exceptions, you can see the final 3 are the most important ones. So a temporary absence of other employees. So textbook example, we've got someone off on work cover, we appoint someone for 3 months on a temporary basis, work cover extended for 3 months, we extend them for 3 months, work cover is extended again for 3 months, we extend for 3 months. That would fall within that exception, and those arrangements are still appropriate. High income earners, so above $162,000 salary now, they can have fixed term contracts, and these provisions have no impact upon them. and roles that are specifically linked to government funding. So, not-for-profit, aged care sort of areas where there is specific funding to provide for particular roles. The fixed term contract can be linked to that funding, even if the funding extends beyond a period of 2 years. And the final point is, again, administrative in nature. You need to make sure that employees are provided with the fixed term contract information statement. So I think, next slide. And just a quick one, a prohibition on job advertisements. So from now, if there is a job that's advertised at a rate that is less than the national minimum wage or the applicable industrial instrument rate, then that is subject to a penalty under the Fair Work Act. And while that looks kind of pretty obvious, there's still administrative errors that can occur that can expose an employer in this space. So, for example, we put a job advertisement in for a particular position in June. We don't get appropriate candidates. We rerun that specific advertisement in July. The new Fair Work Commission increase has come through the 1st of July, and we've inadvertently breached the legislation because we're now referring to the pre-1 July rate. So it's easy to fall into those sorts of administrative errors. And my kind of view is, don't put the rate in the advertisement. Wait until people apply and talk them through the rate as part of the recruitment process. I think that's me, Ben.
Thanks, Alex. So I'll be talking briefly just about the changes to the enterprise bargaining regime that we know will largely come in from the 6th of June this year. I would preface what I'm going to say by mentioning that obviously a number of us have worked in and around enterprise bargaining for many, many years. My view is that these changes have the potential to be some of the most significant that we've seen over that period of time, and hopefully I'll make that clear as we go through the next couple of minutes. So the first key change to be aware of is that as of December 2022, last year, a bargaining representative has the capacity to write to an employer and notify them that it wishes to commence bargaining with them. And that has to occur in certain circumstances. So there has to be a single enterprise agreement that has passed its normal expiry date, and that the time between when that expiry has occurred and the request is made is 5 years. Or sorry, not more than 5 years. The other aspect of that is that the request needs to be made in respect of a scope which is the same or substantially the same as the agreement that's in place. Now, that all sounds relatively straightforward. Once that notice has been given, the employer is, however, required to bargain in good faith. So that presumably is not going to cause significant difficulties for most employers, other than perhaps they were looking to delay the negotiations and they've now been driven into a process whereby they are compelled to bargain. And to that effect, it is a replacement process for the majority support determinations which are currently in play. It is worth noting that the employer can really only push back against that notification if they are proposing to alter the scope of the agreement. So an example might be that you have a site-specific agreement and you're looking to put in place a national agreement. Alternatively, you might have an operational agreement, such as, say, maintenance within a production facility, and you want to have a site-specific agreement and bring those people in. In that case, you may well be able to resist the notice but you would then have to demonstrate that you were commencing bargaining in another fashion. So moving on to multi-employer bargaining, this is probably the section that's received the most coverage in the media, particularly leading up to the approval of the legislation late last year. So there's really two categories that fall under this. The first is what's been referred to as a collective bargaining stream, and it is essentially the same as the multi-employer bargaining processes that we have in play now. One of the key changes, though, is that the parties to a multi-employer bargaining agreement would not be able to go to ballot unless all of the bargaining representatives agreed for that to occur. And obviously that's potentially problematic because we've seen in a number of similar types of arrangement, probably more so in state arrangements, you can have one bargaining agent who holds up the whole process. So the legislation does provide a safety valve in the sense that the parties can make an application to the Commission, and the Commission can decide whether it's appropriate to make an order that the agreement be put to ballot. My experience is that largely employers have shied away from multi-employer agreements and have concentrated on agreements as a single enterprise. That really takes us then to the second grouping of multi-employer agreements, which is the supported bargaining stream. Now, under this stream, a bargaining agent can make an application to the Fair Work Commission and for an authorisation which would compel groups of employers to bargain with that particular bargaining agent or a group of bargaining agents. Now, there are some limitations around that. So the Commission has to consider the rates of pay which are paid in the particular grouping or industry. It needs to consider whether the employers which are nominated form a common interest group. So it may be possible for an employer to say, I'm in retail sales and all of these other employers are in hospitality, so there's not a common interest there. Similarly, the Commission has to be satisfied that the number of bargaining agents involved is manageable. My sense of this is that this is designed to put some brakes around a union effectively putting a enterprise agreement together which would cover a whole state or the whole of the country. Therefore the Commission can refuse it and break it down into smaller groups to make that process more manageable. Now, there are also some limitations in terms of the size of the employer. So if the employer has 19 or less employees, an order can't be made against it. If it has 20 to 49 employees, then the bargaining agent that makes the application has the onus to prove that the parties are or have a common interest. And if the employer has 50 or more employees, that onus swings back to the employer to disprove that common interest is not there. Now, the other way that the supported bargaining stream can be triggered is if the minister makes a determination that a particular industry or sector should be covered by a supported bargaining stream. And if that's the case, then all of those caveats that I just mentioned before are no longer considerations that the Commission needs to take into account. And the Commission effectively must make the authorisation, which will then compel those nominated parties to bargain. Now, the Minister has already flagged through various media communications that he thinks that childcare and the social services or social community services industries are two which such a declaration could be made. The other aspect of multi-employer bargaining is that If agreement can't be reached between the parties, then the Commission has the capacity to deal with it as an intractable bargaining dispute and then make a binding workplace determination as to the matters which will ultimately form the basis of the agreement. One final aspect that's worth noting here is that even if you as an employer don't form part of that bargaining group, it is possible for the union or a bargaining representative to make an application to the Commission to vary the agreement to effectively rope you in. So it has some hallmarks back to the award roping in processes that some of us will be familiar with in the late 80s, early 90s. The difference here, of course, is that because it is an enterprise agreement, the Commission would have to be satisfied that the employees in that employer supported the employer's inclusion in the agreement. As part of the multi-employer agreement. I expected that won't be particularly difficult to do because the union will throw resources at convincing employees how much better off, presumably, they will be under that agreement as compared to the award and so forth. Well, moving forward in terms of agreement making, so most employers that we deal with will fall under that category of a single enterprise agreement. And these are the key changes which I think you need to be aware of. So most employers will have gone through the pain that's in the current agreement of having very prescriptive requirements, technical requirements that need to be met. So the issuing of the notice of employee representational rights, and you can't go to ballot until 21 days after that. You've got to have a 7-day access period. And if there was any mistakes anywhere along the lines up until recent times, then your agreement was kind of null and void because you hadn't met any of those, or your application, I should say, was null and void because you hadn't met those requirements. In recent times, the Act has been amended to give the Commission greater power to overlook those minor or administrative errors. So the Commission, the legislation now will do away with all of those technical requirements, and it has directed the Fair Work Commission to come up with some principles around genuine agreement. Now, the Commission is consulting broadly as to what those principles will look like, and it has put forward a number of questions as to whether they should be principles should be at a high level or at a lower level. So we'll have to wait and see how those principles are ultimately developed, and then there will clearly need to be the development of case law about the application of those principles. So very much a wait and see in this particular space. And as soon as we have some clarity around what those principles look like, then we will certainly communicate that to all clients. Two important aspects to mention here are that there will still be a clear obligation to explain the terms of the agreement to the employees, so that won't change. The second aspect that also then is that there have been agreements which have been made with a very small cohort of employees with a view then that more employees would be engaged after the agreement was in place. So the Commission is now required, or will be required, from 6 June to consider whether the employees who participated in the ballot process are representative of the larger cohort that will be covered by the agreement. In respect of the boot, the legislation reiterates what is supposed to be the current process, which is that it is a global assessment and not a line-by-line assessment. Some of the key changes, though, here are that the Commission no longer needs to go back to the bargaining agents to express its concerns about possible boot issues and then seek undertaking. So the undertaking process will largely be done away with. The Commission, at its own initiative, will be able to amend the agreement such that it addresses any particular concerns that you have. Now, that's a concern because it takes away the control that the parties have over the agreement, because certainly there are cases where the Commission may propose an undertaking which is so unacceptable to the employer that, and it's rare, but it does happen from time to time, that they may withdraw the application, go back and deal with whatever the issue is, and then resubmit a new application after putting the agreement back to employees. That power is from the employer is potentially lost if the Commission at its own initiative can make decisions around approving the agreement. The other aspect of that is that currently, once the agreement is approved, that's it. And that really has been the hallmark for employers, because what you're looking for is a combination of flexibility to be able to manage your workforce on the one hand, but also certainty of cost. And you have that predictability. If you've got an agreement that's approved once, you know it's going to have a nominal life and you can work through that. From 6 June, once an agreement has been approved, a bargaining agent will have the capacity to make an application to have the agreement rebooted if there are circumstances that have occurred which were not foreseen at the time that the application was made. So if the employer proposes some significant roster changes or operational changes, and they're not, and the union believe that employees will be worse off, or the boot will no longer be passed, they can go back to the Commission, make an application for a further reassessment. And again, the Commission can make whatever changes to the agreement it considers are appropriate to ensure that the boot is met. And then finally, in regards to the intractable bargaining dispute, so this process is designed to avoid situations where there is a long-term stalemate between parties as to the negotiation of an agreement and potential industrial action. So the Qantas disputes come to mind immediately. So the trigger for this to be enacted is that there has to have been 9 months of negotiation, or at least 9 months of negotiation that haven't resulted in a successful negotiation outcome, or 9 months have passed since the nominal expiry date of the agreement. The Commission has to be satisfied that the parties are at a point where they can no longer reach any further agreement themselves. And at that point, on application, it can make a determination that an intractable bargaining dispute exists. It can then direct the parties to go into assisted conferences to see whether those disputes can be resolved. But ultimately, if they can't, it can then make a intractable bargaining dispute order, which will determine what the outcomes will be for the enterprise agreement. So in effect, the Commission can determine what the agreement will say. And then just very quickly, in terms of the agreement termination, there will now be greater restrictions on the capacity of an employer to terminate an agreement. Particularly, the Commission will need to take into consideration whether the one of the bargaining parties will be worse off as a result of the termination of the agreement. So that, in my experience, a lot of employers didn't actually terminate an agreement, but they certainly used it as a bargaining chip or a threat in the negotiations that was potential if the employees didn't come to some reasonable position. And then lastly, with the zombie agreements, obviously zombie agreements are agreements that have been in place since at least before 1 January 2010. The employers that have those agreements are required to advise employees by 6 June 2023 that they have those agreements in place and that they will lapse. And if no action is taken to extend the life of those agreements, then the agreements will automatically sunset on 6 December 2023. All right, so I'll leave my area there and ask Sarah to take over.
Thanks, Ben. I'll be providing an overview of the main changes coming from the Respect at Work reforms and some of the practical actions or tips that organisations can start implementing to address these changes. So the Respect at Work legislation passed into law in late November last year, and the legislation enacts several further recommendations from the 2020 Respect at Work report. The most significant change, and one that has been spoken about, I think the most in communications or articles on this topic, has been the shift in focus of the law, which previously focused on dealing with sexual harassment and discriminatory conduct in a very reactive and complaint-driven approach. So the shift is now moving with this new legislation to a focus of employers on preventing the conduct from occurring in the first place. Employers were already exposed to vicarious liability under the Sex Discrimination Act and other legislation for actions of their employees in the workplace in relation to this type of conduct. But the new changes elevate the focus directly on employers to take proactive measures to prevent the conduct, which requires a lot of risk assessment and understanding what risks are present in the workplaces that they have. It's also important to highlight that the reforms operate concurrently also with a lot of recent and upcoming changes in state and territory work health and safety requirements that provide now with various codes of practice and other documentation. They provide obligations on employers to address sexual harassment and sex discrimination as a psychosocial safety risk or hazard. So this is sort of an evolving space that we think is going to be a lot of focus on over the next 12 months. Could I have the next slide, please? So what are some of the specific key reforms that have come into place or are already come into place? And as I've mentioned, one of the key changes has been the focus on the positive duty for employers. This came into effect from 13th of December last year when the legislation was given royal assent. So the obligations are on employers and also PCBU, which is terminology that comes from like work health and safety laws, and that's persons undertaking a business, persons conducting a business or undertaking. So it's broader in its scope now, and the obligation on them is to take reasonable and proportionate measures so far as possible to eliminate sex-based discrimination, sexual harassment and victimisation. The conduct, it applies to conduct that could be engaged in by the duty holder themselves, so the employer or the person that owns the business, their employees, workers and agents, or even third parties. So in certain cases, this could be extended to customers and suppliers and other third parties who operate and conduct within the services within the workplace. With determining what are reasonable and proportionate measures, there's a number of factors to consider. Factors such as the size and nature of the business, the makeup of the workforce and the resources available to the business or the organisation. So that's sort of determines whether in practicality some measures are deemed reasonable because of the size of the organisation or their financial resources and other resources they have available. It's important to note that the positive duty doesn't require an employer to prove that the conduct's impossible, but rather that they've taken all sort of appropriate proactive preventative measures to minimise the likelihood or the incidence of such conduct occurring. It's similar to the positive obligations imposed by work health and safety legislation, which requires that where complete elimination of a risk is not practical, an employer must still demonstrate they've taken action to minimise the risk as far as reasonably possible. Another new provision that took effect from December last year is the addition to the Sex Discrimination Act of a prohibition on conduct that subjects another person to working in a hostile working environment on the grounds of sex. So for the conduct to be prohibited with this provision, it needs to result in the workplace being offensive, intimidating or humiliating to a person by reason of the sex of that person. It's important with this new provision to point out that the behaviour or conduct doesn't need to be directed at one person in particular. So it could include conduct that involves, say, displaying obscene materials in the workplace, engaging in general sexual banter, or telling offensive jokes that result in people of one sex feeling unwelcome or excluded from the workplace. The circumstances that will be considered when determining if that conduct is unlawful with this new provision includes the seriousness of the conduct, whether it was continuous or repetitive or a one-off, and the role and sort of influence or authority of the person that was engaging in the conduct. These protections apply to workers in the definitions in the legislation, and this aligns to the definition of worker in work health safety laws. So it's broader than the usual kind of assumption of what an employee category is. So it also includes subcontractors, labour hire workers, volunteers, students and interns as some examples. From the 6th of March, so Monday next week, there's another new reform that will take effect, which is inserting a prohibition on sexual harassment in the Fair Work Act. This will also introduce a new complaints mechanism for the Fair Work Commission, where they'll be able to make compensation orders or orders to redress loss or damage. The Fair Work Commission will be able to deal with the disputes that are raised through conciliation or arbitration and make orders to settle the disputes. It's important to point out that these requirements relate to workers or employees, but also prospective employees, and that the complaints or claims can be lodged on behalf of an employee by their industrial organisation. The new complaint function only applies to sexual harassment that occurs or begins to occur after March 6, but the Commission is also retaining its powers to make anti-sexual harassment stop orders. So those are similar to the anti-bullying stop orders that have been in place with the Commission for some time. So this new complaint mechanism is in addition to that function of the Commission. Last week, the Commission released like an implementation report to seek some feedback on this new complaints mechanism. And I understand they'll be having a sexual harassment disputes bench book available pretty soon. But with this all commencing from next week, it's really a watch and see in terms of as complaints start to come through the commission. It'll be interesting to see the case law that we see coming through. From the 12th of December, so not taking effect until later this year, there will also be changes to the powers and functions of the Australian Human Rights Commission. So this will be for them to monitor and address compliance with that positive duty obligation. They will have an enhanced inquiry function to inquire into systemic unlawful discrimination and harassment, but it's important to highlight with this one that it's not where they just believe there's actual systemic concerns. It actually can also be suspected as well. And they'll have powers to give compliance notices to employers and also enter into enforceable undertakings in cases where compliance is not able to be achieved through other measures. I'll move on to the next slide, thanks. So there's obviously a lot of changes in this respected workspace that are they're coming into effect or still to come into effect, and obviously new complaints mechanisms and powers for the governing bodies. So in terms of what that means for some sort of practical measures that companies can start putting into practice now, one of the first areas we would suggest is reviewing and updating current policies. So this is obviously policies on work-based behaviours, discrimination and sexual harassment, but we also suggest looking at what policies say for social media and out of hours conduct, like behaviour that takes place at workplace events and conferences and things like that. It's also important for companies to review their existing complaint and reporting procedures to ensure that these sort of are robust and aligned to these new requirements. A key component of addressing some of the additional requirements now for employers, particularly around the positive duty, will be conducting training for staff. So where currently organisations may have in place compliance training, like the new obligations and requirements really put an additional sort of onus on considering the best way to sort of have the training so that it's more meaningful, and it's instead of being too generic, it's actually very specific to the issues and the potential risks in the workplace. So what we would recommend is that perhaps rather than in the past where training may have been online, it might now require some more detailed training being taken place that allows for sort of questioning, discussion, going through either case studies with employees or sort of hypothetical scenarios. And it was going to be very important for employers to be running some separate additional training for supervisors and managers so that they understand their role in preventing harassment and also in managing complaints that might arise. With the positive duty obligations and some of the other changes, it's going to be important for companies to ensure that their work health and safety risk assessments are broad enough to cover risk of psychological injury caused by sex-based harassment or sexual harassment, and that they're able to demonstrate actions and mitigations that they're taking to control risk. So this will involve, as part of the risk assessment, really identifying and addressing specific risks that might apply in the workplace, and particularly if it's things like there's remote work or other features of the workplace that increase the level of risk in these areas. An important component that sort of ties into that risk assessment, it will be for organisations to be able to measure and monitor data in this, like their own HR data in this space. So that could include measuring and monitoring the prevalence of sex-based and sexual harassment complaints or cases that they've had in the organisation. So the nature and number of complaints, and also how they were resolved or addressed by the organisation, what the company's response and outcome was. It could also include looking at company employee surveys, so things like engagement surveys, culture surveys, and also exit interview data. And another recommendation is, in some organisations, the use of cultural reviews, which would involve conducting interviews or sometimes focus groups or surveys with members of the workforce to also try to get a better understanding of people's concerns or experiences with harassment and discrimination in the workplace. It's going to be interesting to monitor this area and the impact of the changes over the next 12 months. I think particularly with the new sexual harassment dispute complaint mechanism for the Commission, and also once the additional powers and functions of the Australian Human Rights Commission come into effect as well. And we'll be keeping clients informed as we see developments and there starts to be case law in this area. Hand back to you now, Ben.
All right, thanks, Sarah. Appreciate that we're running a little bit short on time, but we are very interested in understanding what are the key areas that people would like more information around. So, Joe, if I could ask you just to quickly put up the survey. People could take a moment just to nominate. All right, Joe, if you could just let us know if that's done. And I guess in the time that we have left, if there were any questions that you were able to put up.
Just share the results of the poll now. We've got about 70% of people who voted. Great.
And obviously, to anybody who's a participant in the webinar, if you have any questions about anything that we've spoken about today, please don't hesitate to reach out to us and we can talk more directly about what your particular concerns are. And Joe, were there any questions that you wanted to put up?
I do have a couple. The first one was just with enterprise bargaining changes, are there specific industries or sectors which are more exposed to the risk of being roped into supported bargaining streams?
Yeah, okay, thanks, Joe. So look, on that one, certainly there are some industries which we know will be targeted, so childcare and social community services I mentioned. I think hospitality, retail, manufacturing, pretty much anywhere that there is a union presence, but they haven't really been able to affect enterprise bargaining because of a lack of significant numbers of members on any particular site. Also, we're taking retail, for example, or indeed hospitality, where the union has limited resources to get around and service multiple workplaces, particularly where those workplaces might be kind of in that, obviously they need to be more than 20 or more, but that quite easily could be any number of, say, fast food outlets or restaurants or so forth. I think just because there's the potential for people to be roped in doesn't mean that they need to kind of think that that will automatically happen. I think the key here is to have a well-considered strategy around enterprise bargaining, because obviously if you're forced into negotiation, then largely you've lost control of that process, and you're sort of trying to catch up. So either you potentially want to look at going in to start an enterprise agreement yourself directly with employees, or if you choose to stay on the award, then your strategy needs to take into consideration other things, including some of the things Sarah has spoken about in terms of, say, your remuneration strategy or your engagement strategy with employees, so that the relationship that you have with employees is as positive and functional as it can be, so you're not giving the union the opportunity to make inroads. Back to you, Jo.
Thank you. Alex has been answering a couple of questions in the background, but I do just have one more. How do you think FTCs will apply to the O&G industry, where you generally only have a contract with your client?
That's probably my area. Yeah, I think that's a tricky one. It doesn't seem to fall within any of the specific fixed term contract exemptions, and I guess this issue is kind of broader than oil and gas. It would go into any area where you contract into another organisation for a fixed period of time, which is greater than the 2 years. So unless it fell within the specialist role, it probably doesn't fall within the exemption. I also gave some answers in writing in relation to some of the visa holder scenarios. And what I flagged there, it's probably of note, is that while there's currently a list of various exceptions and exemptions to the 2-year fixed term contract arrangements, there is a provision which allows the government to set regulations which will identify other circumstances where this will occur. So my view is, in relation to visas, is that is likely to occur at some future date for those, and it may be where issues of concern like this are identified, that there'll be some flexing up for exemptions, but there'll clearly be pressure by the unions to not extend those exemptions and to make all those employees permanent, because at the end of the contract, if they're permanent, then they would be entitled to redundancy payments unless it's already factored into some other arrangement under their enterprise agreement.
All right, Jo, we probably have time for one last question.
I think we've covered them off. I do see we've got a couple of people asking if there'll be presentation notes or if we'll be getting the Q&A out to everyone, and I know that will be circulated later, but otherwise, no more questions.
Great. All right, on that basis, I'd like to thank everyone for their attendance. Hopefully the presentation has been of value to you and giving you some understanding at obviously at a very high level as to the changes that we expect over the next 12 months or are already in place. As I said before, please, if you do have any questions, don't hesitate to reach out to us, and we'd be more than happy to provide any specific advice that we can to your circumstances. On that basis, we'll end the presentation. Thank you.
Thanks, everyone.
Bye.